Good afternoon, everyone. Welcome to Cliff Decker Hofmeier's webinar. We'll be dealing with the Competition Amendment Act provisions dealing with buyer power and price discrimination, and as well as the various BE and income tax related considerations when you consider these difficult provisions. Just while everyone's getting ready, we must mention that this is subject to a disclaimer. This presentation is not intended to constitute legal advice, but we'd be happy to address any questions that you may have afterwards. I have with me Varishka Pillay, who will be dealing with the BE aspects, and Jerome Brink. And the way we've scheduled today's session is that I'll deal with the Competition Act aspects first and then hand over to Varishka, and thereafter to Jerome. They'll deal with their respective portions. At the end, we'll allow for a question and answer session, and if you have any issues, please feel free to raise them during that session. By way of introduction, we've spent the better part of a year and a half or more dealing with the new Competition Act provisions which relate to buyer power and price discrimination aspects, particularly in relation to small and medium-sized enterprises and historically disadvantaged firms. These provisions have been perceived as being quite challenging for our clients as well as our colleagues, because they introduce fairly new provisions that are not customarily dealt with under the competition legislation. I think what's complicated things, particularly in the last while, is the COVID-19 implications for various businesses. And in particular, I think the focus seems to be shifting onto protecting smaller firms or customers who are subjected to price hikes during these difficult times. So we do definitely find ourselves in uncharted territory, and an area that is probably going to be developing quite significantly over the next while. The approach we've taken today is not to go into the detail of the buyer power and the price discrimination provisions, because that could take quite a long time. What we've decided to do is to provide a broad overview of the provisions and deal particularly with how they relate to certain BE considerations as well as certain income tax considerations. We often find that advice that we give in this area needs to be tailored to account for various commercial imperatives that are operating within the client's business, and therefore we've decided to position this presentation within the context of these areas of the law as well. I think within the times that we live in, it's quite clear that there are various COVID measures that rely upon various income tax incentives, and Jerome will then talk us through how these incentives can be utilized in these particular times for the benefit of small and HDP firms, as well as to try and cushion the effect of compliance with these provisions by seeking to deduct the necessary expenses if you can under the Income Tax Act. There have been various praiseworthy initiatives during these times, such as the creation of the Solidarity Fund and the donations made to support these funds. I think one experiences the definite realization among firms that we are all somehow related to each other, the small firms and the dominant firms. And many dominant firms that we consult with have initiatives underway where they have programs, supply development programs, customer development programs that all seek to promote the interests of these firms. And we'll deal with how these programs could potentially serve as a basis upon which to seek to comply with the provisions of the Competition Act. The recent buyer power guidelines that have been issued have something to say about these programs, as well as the price discrimination guidelines that we have before us and that are currently still in draft form. We will try to to provide practical experiences during the session, and we hope that what we have to say will be useful. I think that the provisions, the buyer power provisions, price discrimination provisions have also occurred within various market studies during this time, such as the grocery and retail sector investigation, as well as the automotive industry investigation and guidelines that have been issued. Both of these market studies and guidelines also focus on the role of smaller firms and HTP firms within the economy. And there's a clear intention to try to facilitate the greater participation of these firms within the economy. One of the difficulties I think that one faces in dealing with these things is that as a lawyer, you're faced with terms such as unfairness or obligations that are placed on dominant firms to seek to achieve greater participation by SMEs and HTP firms within the economy. And this poses significant challenges for lawyers when they try to grapple with what it means for their business. The lessons we've learned from some of the work that we've undertaken is that if you're dealing with a concept such as fairness, all the facts and circumstances are clearly going to be relevant. In these times, the focus very much is on trying to protect the interests of smaller firms, HTP firms, but because of the COVID-19 epidemic, large firms that are perceived to be dominant, who often are thought to have deep pockets, are also struggling significantly. One can just think of firms such as SAA, which was a dominant, strong firm until recently and is now in dire straits. So the important aspect that we feel is necessary to focus on when we consult with our clients in this regard is that fairness is a concept that is difficult to define, but is very, very dependent upon all the facts and circumstances of the particular firms. And therefore, a lot of work is needed to be done to actually dig down and consider who are these customers and suppliers of yours that are required to be supported under the new provisions of the Competition Act. How are you going to collect information regarding who they are? How are you going to verify that they fall within the relevant categories? And those are the things where we believe the BEE provisions as well as the income tax provisions might assist firms to the extent that they already have these types of programs underway. Just briefly, before we get into some of the detail regarding the identity of the firms that we're dealing with here that are worthy of protection, just to give you a brief overview of what these provisions seek to do, to the extent that you haven't delved down into them. The first provision in the Competition Act dealing with buyer power is contained in Section 8.4, and the provision essentially seeks to prohibit dominant firms from pricing unfairly or imposing unfair terms and conditions on these categories of vulnerable firms, namely SMEs and HTPs. And there's also an anti-avoidance provision which says that it's a contravention to avoid dealing with these particular firms. Now that poses significant difficulties if your business is not geared towards dealing with firms in these categories, and that's where we think that it might definitely be useful to try to focus on certain of these supplier development or customer development initiatives that are currently features of many corporate activity when you look at BEE initiatives, because these programs are already geared towards at least demonstrating a level of compliance with the Competition Act, in the sense that they have as their targets firms that are smaller and also firms that are comprised of historically disadvantaged individuals. The buyer power provisions are complex. The guidelines that have been issued are complex because they try to go down into the detail of what fairness would constitute in certain cases. And as I said before, as a lawyer, one automatically understands and perceives that fairness is really dependent upon all the relevant facts and circumstances. So the attempt to try and prescribe or give guidance regarding what fairness might comprise of in certain circumstances is very difficult. The types of provisions that you find in the guidelines relate to unfair terms, such as where suppliers are not paid in time, not paid within 30 days. A lot of these ideas and these examples are drawn from other jurisdictions such as the EU, and they might not always be so applicable in our circumstances. Similarly, if you look at the price discrimination provisions, the new provisions under Section 91A Roman numeral 2, the price discrimination provisions now seek to prohibit price discrimination in relation to SME firms and HDP firms, where such price discrimination would impede these firms from participating effectively in the economy. And once again, the difficult issue here is how do you define what effective participation involves? How do you balance the interests of dominant firms versus smaller firms when you are seeking to impose these additional obligations on dominant firms? And if you look at the guidelines, the price discrimination guidelines, you'll see that a lot of the focus falls on the interests of SME firms and HDP firms. There's very little consideration of the interests of the dominant firms in these guidelines. And I think that's definitely an area where one would need to try and lobby the Commission at least to appreciate the difficulties that dominant firms find themselves in, and in certain cases, the extensive obligations that these new provisions might place on dominant firms. Once again, to the extent that firms have enterprise development programs in place, they may well have better insight into what's happening within their customer base than firms that don't participate in these initiatives. And that's where we believe there might well be an extent of overlap between the provisions of the Competition Act and the BE provisions, because the programs that firms already are engaging upon or participating in might give them a greater level of insight of how their customers are struggling to participate in the economy, how they are perhaps struggling to operate profitable businesses. And to an extent, the information gleaned there might be used productively to consider how they adjust their conduct under the price discrimination provisions. So if we just return to the theme that I mentioned up front, namely, which firms do these provisions seek to protect? And that's perhaps the best starting point, is to look at when you have your business running and you're dealing with customers on the one hand, you're dealing with suppliers on the other hand, which of these customers and suppliers are going to be the ones that you need to exercise particular care in relation to when you try to mitigate the risks of these provisions in the Competition Act. The areas where we believe there may well be overlaps in relation to the BE legislation, we'll deal with them now, will be highlighted in a set of slides that we're going to put up. Perhaps can I just ask our administrators to just put the slide up dealing with the various firms. That will be, there we go. Thanks. So you'll see from the slide that this is a regulation that's been published that indicates the various levels of small and medium-sized firms that will benefit from the provisions in the Competition Act. Agriculture, for instance, you'll see micro enterprises, small enterprises, medium enterprises. Now, the Act doesn't seek to protect micro enterprises, interestingly enough, but only small and medium-sized enterprises. And you'll see that different sectors have different levels of annual turnover applicable to these firms. So that's the one set of customers that are going to be worthy of protection. So we can just remove that slide. Thanks, Karishka. The other category of firms that are going to be protected under these provisions are historically disadvantaged firms. And here, unfortunately, there is some there's certain contradictory provisions in the Competition Act as well as the regulations and guidelines as to which firms exactly would qualify as historically disadvantaged persons. If you look at the section 8.4 and section 9, you will see that firms are referred to under this category as either being controlled or owned by historically disadvantaged persons. Now, so you potentially have firms either controlled or owned by historically disadvantaged persons. But if you dig down into the guidelines as well as into the Act itself, there are provisions that suggest that you must satisfy both requirements, namely firms must both be controlled and owned by historically disadvantaged persons in order to qualify. And that is borne out by section 3(2)(c) of the Act that refers to these categories of persons that are protected, and in that case also refers to ownership and control being the relevant consideration. So this is an aspect that will require to be clarified. I think currently one could probably assume the position that ownership and control is the relevant consideration. But in this regard, one of the difficult questions is, how do you know whether your customers or your suppliers fall in this category? You know, how do you know? You don't have any insight into their ownership structures. You don't know how they are controlled, and the element of control that is relevant is a broad concept potentially, because under the Competition Act, control could even involve some form of minority interest with control rights. Here again, we believe that it might well be possible to extend the practice that exists under the BEE legislation, to have verification agencies that can provide you with confirmation, or you might be able to use the database that you've compiled in complying with BEE legislation to identify these firms and to check whether they fall within these relevant categories. It is interesting that the Competition Act guidelines suggest that it's not permissible for dominant firms to go and collect detailed cost information from their customers or their suppliers in order to check whether they are compliant with the provisions of the Act. But once again, we believe that if you have programs in place where you are mentoring firms that fall in these categories, you will at least have better insight into their costing structures, perhaps their dependencies, their vulnerabilities, on the basis of which you may be able to better plan and mitigate the risks under the Competition Act. Just to close off, the guidelines, the price discrimination guidelines, as well as the buyer power guidelines, both contain references to provisions which deal with programs, HTP or SME programs, and the relevance of these programs in the life of a dominant firm. Both the provisions say that if you have such programs in place, you won't be able to rely upon them in order to mitigate the risks under the Competition Act. But there's definitely a recognition of the fact that these programs would serve potentially to demonstrate compliance to a certain extent, or at least would allow you to argue that if you are faced with a fine, that these factors should be considered in mitigation, because the sections in the Act dealing with penalties referred to the conduct of the firm as being one of the relevant factors that are to be considered. So I think from my perspective, this brings me to an end of my section, and I'll now be handing over to Verushka, and she'll then deal with the areas where the BEE legislation might dovetail to an extent with the competition provisions. Thanks very much.
Remember, unmute. Rishka, please unmute.
Oh, sorry. Apologies. Before I proceed, I wanted to indicate to you that we have a Q&A panel into which you may insert any questions you have, and we'll deal with those questions at the end of the session. As Andres mentioned, there is an extent to which these amendments to the Competition Act can dovetail with the provisions in the BEE codes. And it's worthwhile considering the extent to which the BEE provisions may be leveraged to aid compliance with the Competition Act. Of course, the two pieces of legislation were not designed to speak to each other. So there are limited ways in which one can draw parallels, but certainly there are useful aspects for us to consider. Firstly, we must note that the Competition Act doesn't use the term Black people, which is the defined category of beneficiaries under the BEE Act and the BEE codes. Instead, it refers to the term historically disadvantaged persons. Nevertheless, the terms do appear to be analogous because in terms of the Competition Act, a historically disadvantaged person is a person who falls into a category of individuals that was disadvantaged by unfair discrimination on the basis of race prior to the publication of the Constitution of South Africa of 1993. So that would certainly include the concept of Black people as one understands it in terms of the BEE Act and the BEE codes. Then a further distinction in the Competition Act is between firms that are small and medium businesses on the one hand, and then firms that are owned and controlled by historically disadvantaged persons. So that the prohibition on the treatment of firms owned and controlled by historically disadvantaged persons isn't limited by the size or the turnover of that particular firm. In addition, small and medium businesses are those that are categorized as such in terms of the schedule to the Competition Act. And if you can have a look at the slide that we have in front of you, you'll see that those categorizations are made on the basis of the relevant sectors in which the businesses operate, the number of employees, as well as turnover. The turnover indicator for a small business under the Competition Act is only consistent with the turnover classification of a qualifying small enterprise in the BEE codes. What that means, and as per the slide, a qualifying small enterprise, or a QSE, is one with a turnover of between 10 and 50 million rand. On the Competition Act schedule, you see that fits within the classification of a small business, which is between 11 and 50 million across the relevant sectors. I suppose that's important to note to the extent that you are familiar with the classifications in the BEE codes, that there are exempt micro-enterprises under the codes which have a turnover of 10 million rand or less, and large enterprises that have turnovers in excess of 50 million rand. It's important to note that QSEs and EMEs that are at least 51% Black owned are the only entities that are eligible as beneficiaries of enterprise and supply development contributions under the codes. We do think that given that there's a long history of BEE compliance, dominant firms that focus on their BEE compliance will likely have systems in place that require all their suppliers, regardless of turnover or ownership status, as well as their enterprise development beneficiaries, to submit their BEE verification certificates to them annually. These certificates will indicate the entity's turnover classification under the codes, as well as the extent of black ownership, given that that is a measurable item under the codes. And for purposes of gathering information in the context of price discrimination and the buyer power provisions of the Competition Act, this can be quite useful. The verification certificates will go a long way to assisting with the turnover classification as well as the black ownership classification, to the extent that the employee number references are relevant. Those cannot be gleaned necessarily from the verification certificate, but certainly this is a clear opportunity to update a dominant firm's existing processes with regards to BE information collection, to also include any information relating to a supplier or an enterprise development beneficiaries classification for purposes of the Competition Act. And one of the benefits of using the existing systems is that suppliers and enterprise development beneficiaries are quite accustomed to requests for their BE certificates and related information. And since you may require only limited additional pieces of information, we believe it's unlikely that a firm will refuse to supply that information. But again, if for any reason there is a refusal to supply information, we believe that a dominant firm should be able to insist that the information be made available to it in order to just generally mitigate any risks arising from the buyer power and price discrimination provisions. There are three, just touching on the provisions of the codes and the scorecards, there are three broad areas where a dominant firm can benefit from enterprise and supply development points on its BE scorecard, both in relation to black-owned entities and small and medium businesses, and which we think can be considered more closely to at least try and mitigate some of the price discrimination and buyer power risks under the Competition Act. So these include where the dominant firm procures goods or services from firms that are QSEs, regardless of their black ownership. They will have a BE compliance level in terms of their BE verification certificate that will be available in terms of the information that's been provided to the dominant firm. Then if the dominant firm procures goods or services from firms that are at least 51% black-owned large enterprises, EMEs or QSEs, and if it supplies goods or services to firms that are at least 51% black-owned QSEs or EMEs. So just to expand on those areas, where the dominant firm is the buyer, early settlement of accounts for QSEs that are at least 51% black-owned can qualify as a form of supply development contribution. In addition, a supplier that is a 51% black-owned QSE could be included as a participant in other aspects of the dominant firm's supply development program. Examples of qualifying supply development contributions include the provision of funding, the advance of grants and payments of other business-related costs to facilitate the sustainability of that entity. The codes, of course, contain a variety of examples of types of supply development contributions. Then, where the dominant firm is the supplier of goods or services to QSEs and EMEs that are at least 51% black-owned, things like the provision of credit facilities, favorable credit terms and discounts are among the examples of qualifying enterprise development contributions that can be made to such firms. So therein is an opportunity in relation to HDP firms. So in summary, there are benefits to considering leveraging of a dominant firm's existing BE compliance processes to assist in the management of the buyer power and price discrimination provisions in terms of the Competition Act. I'll hand over now to Jerome.
Thank you, thank you, Varishka. I think, as the old cliched saying goes, only two things in life that are certain, that's death and taxes. So generally, tax follows your sort of commercial rationale, and whatever you're doing from a Competition Act amendment perspective and your BEE legislation, your tax generally follows. And this is no different. But the tax implications are very technical and detailed, and so the focus of today's talk is more just going to give a broad outline of some of the key tax principles that dominant firms should be aware of or should consider when they're embarking upon these compliance programs and empowerment initiatives. So before diving into some of the key tax considerations, it's worth visiting sort of a common theme, and that's sort of the alignment or perhaps misalignment between some of the pieces of legislation. And that includes the BEE legislation, Competition Act Amendment, and the tax legislation. So there's a graphic now being shown to you which broadly outlines some of the sort of categories in the Tax Act regarding SMMEs. Right at the top, you have sort of your formal sector. That's where your dominant firms would be sitting generally, and they taxed at a flat rate of 28%. You then have your SBCs or small business corporations, and they're in the next category, and the qualification there is that they have gross income that must not exceed 20 million Rand per annum. And then right at the bottom, you have your registered micro enterprises, and their qualification is that qualifying turnover does not exceed 1 million Rand per annum, and they taxed in terms of a special turnover tax system. So the SMMEs, if you do qualify and you fall into those categories, you do get taxed with different rates as opposed to your flat tax rate. I think it is evident just from looking at that graphic that the Tax Act doesn't necessarily speak to, let's say, the BEE codes or the Competition Act Amendment, and there is a bit of a disconnect. But from a dominant firm perspective, it's important to keep in mind that when you are, from a tax perspective, the identity of whether your supplier is an SBC or registered micro enterprise, or let's say just a normal company being taxed at a flat rate, is not necessarily or in itself going to make a difference as to whether you're going to fall within certain tax provisions or outside certain tax provisions. Following on from this theme, it should be noted that there are no specific tax provisions or incentives that deal with empowerment in the Tax Act, and government and National Treasury has always been cautious and hesitant to create these types of carve-outs. And this is no different in respect of these new provisions from a competition perspective. And so it's important that ultimately you need to look at your general tax principles. And so the focus of my talk is going to be to briefly discuss your general tax principles, and that's section 11A, where you get your income tax deduction, but with a specific focus on how it's impacted specifically with SMME development and contributions to SMMEs. With that being said, there are some provisions in the Tax Act that are focused on SMMEs and that dominant firms could consider potentially utilizing. Again, it's dependent on what industry you're operating in, your commercial, rationales and sort of factors. But there are one or two that could possibly be helpful, and that includes your Section 18A donations to PBOs, Section 30 Cap C small business funding entities, and Section 12J VCCs. Then at the end, we will just briefly discuss some of the recent COVID-19 tax relief measures, which are still undergoing in a public consultation process. And we will specifically highlight one or two that dominant firms could possibly utilize in showing their compliance with these new amendments and through a BEE perspective. Okay, so general principles. I think the key issue is your section 11A, and that entitles you to your income tax deduction. So it's your deduction against taxable income. Always the key issues is whether it's incurred in the production of income, so it's for productive expenses, whether it's a capital or revenue in nature, and whether it's been partially or wholly expended for purposes of your trade. Clearly from a buyer's perspective, where you are engaging with your suppliers and let's say you pay more for goods or services that they render to you, then you will likely, specifically with services, if those are in the production of income and you meet those requirements, you will be getting an income tax deduction that, let's say, you wouldn't have had previously. If you look more broadly towards empowerment expenditure and enterprise development expenditure, one of the key issues is to focus on some of the principles that have been established specifically from an empowerment expenditure perspective. And the foremost case in that regard is the Warner-Lambert case. And essentially what it involved was a South African subsidiary of an American parent company. And there was legislation introduced in America that subsidiaries of American parent companies need to incur certain social responsibility expenditure. And the tax court, or the court, ultimately held rather that that expenditure would be deductible, and it was akin to sort of insurance premiums to ensure that that subsidiary wouldn't lose its status and would therefore continue trading. So critically, a principle established in Warner-Lambert that many dominant firms can fall back on in order to claim expenditure that is incurred in this type of environment. But again, very fact specific, and there are certain requirements and certain issues and principles established in that case. So dominant firms should be careful when they are engaging in these programs and initiatives to make sure that they have a good understanding of those principles to ensure that it's conducted in an efficient manner. The other important case is the pick and pay wholesalers case, and essentially there the court had to consider the deductibility of a donation to a charity. And I think the key issue here is, well, then the good analogy that came about in this case was, or that was discussed, was the two different hats that you have, and sort of where you're sitting with your business hat, your commercial hat, and you're incurring expenditure in order to get a quid pro quo. In other words, there's a commercial rationale and a business rationale behind that expenditure, then you're more likely to get the deduction, or your argument is stronger. And in the other case, where you're doing something that is gratuitous or philanthropic, and you're not interested in the outcome, it's then akin to a donation. And in the second category, you're more looking then towards getting your Section 18A deduction, as opposed to, let's say, your income tax deduction for purposes of 11A. Another principle that firms can rely upon are SARS rulings. Just for those of you that don't know, SARS ruling is essentially where taxpayers can apply to SARS on the basis of a proposed transaction that's not necessarily certain, and you can set out a set of facts, and SARS can make rulings in terms of the accepted tax treatment for that transaction. There've been a number of rulings in the empowerment space, and that have sort of developed the principle that certain expenditure, especially enterprise development expenditure, can be deductible. So they have established a good principle. Just one example was the ruling number 282, and there a renewable energy wind farm had to incur certain enterprise development expenditure and SED expenditure for purposes of being able to operate as a renewable energy wind farm, and to ensure that the agreement wasn't terminated. And so they contributed an amount to a trust, and then that trust was going to undertake some enterprise development activities as well as socio-economic development activities. And critically, SARS ruled that you allow the deduction in terms of Section 11A, and there's no donations tax on that contribution. So I think in sort of summary in that aspect is that there is no specific provision that's going to help you automatically. You need to understand the general principles and leverage off those general principles when you're conducting these compliance programs, and also from an empowerment perspective. I think one aspect that I did touch on a little bit earlier is Section 18A and public benefit organizations. So say dominant firms, in order to show their compliance with the Competition Act or with the BEE codes, they take a more philanthropic or altruistic sort of approach to things. They can look to the Section 30 public benefit organizations, and if they contribute or make donations to those organizations, and now again, this is with your sort of philanthropic hat on, referring to the pick and pay case, they can claim an income tax deduction. Benefit is, if it's a PBO and it's conducting the correct public benefit activity, you get that deduction and there's more certainty for taxpayers. Downside is that it's not necessarily going to help you too much from an enterprise development perspective, but more from your BEE codes and your socio-economic development expenditure. And that's particularly the case because your public benefit activities are so limited in terms of welfare and humanitarian, education and development, and those types of activities. Another specific provision that dominant firms could possibly consider is the Section 30 Cap C small business funding entities. Essentially, they act as conduits for funding for SMMEs. You basically contribute to the small business funding entity, and they then provide financing to your underlying SMMEs. Benefit of using this type of arrangement is that the SMMEs who then receive the funds are potentially receive a preferable sort of tax treatment. The downside is that you've got to again fall back on your general tax principles, and is your expenditure then being incurred in the production of income, and you've got to look at 11 Cap A. Sub A. A last sort of incentive that is front of mind and that a lot of people often talk about is Section 12J, which is your Section 12J venture capital companies. Generally, your expenditure to subscribe for shares is not deductible against income, but Section 12J is a specific provision that allows you to subscribe for shares in a venture capital company that then in turn subscribe for shares in underlying qualifying companies, and these qualifying companies are generally SMMEs. Again, showing a bit of a disconnect in that the qualification in that section refers to a book value of assets that the qualifying companies have, as well as a number of other requirements. And so there is a little bit of a misalignment in that regard. We have seen some 12J companies that have tried to work within the enterprise development space. The difficulty with 12J is that it is quite a technical area, and there are quite a few limitations and restrictions. And so it does become challenging to make sure that your structure works within that specific provision, but ultimately definitely beneficial. I think the other note or important thing to remember is that it is up for renewal. So National Treasury is currently looking at it. And there is a sunset date, original sunset date of June 2021. So we're not sure as to whether it will continue beyond that date, particularly because a lot of VCCs we've seen have not necessarily provided the outcome that was initially intended for. Again, just to sum up, no specific solution here for dominant firms. However, it is important for them to realize that there's a lot of potential tax implications and a lot of some specific incentives that they could possibly use. But again, it depends on the commercial rationale, the industries they operate in, and that will sort of inform them as to what type of arrangement they could utilize and the tax implications that follow from that. I think we're going to move on now to the COVID-19 tax relief measures, obviously something that's very topical at the moment, and they were predominantly obviously introduced focused on SMMEs. We've put a graphic up now which you should be able to see summarizing some of the tax relief measures, and we've also posted this graphic on our social media platforms, so you should see it. It is an ongoing process. There've been a number of bills and a number of changes to those bills. It is sort of in a dynamic environment at the moment and ever changing. I think one of the critical aspects is the deferred payment of provisional tax and employees tax. And something to remember is, again, with this definition of what constitutes an SMME from a tax perspective, and in terms of the relief measures, the current proposal is that tax compliant small to medium sized businesses with an annual turnover not exceeding 100 million will potentially fall within that category of tax relief measures. So again, possibly broadening that base of SMMEs, and I'm sure a lot of SMMEs are very welcomed to the extent that turnover amount has been exceeded. I think something for dominant firms to possibly look at is the Solidarity Fund, which Andries did mention earlier, and critically a disaster relief fund is something that it does fall within one of the public benefit activities, and it is specific that the Solidarity Fund and similar funds could become Section 18, or if you meet the certain requirements, 18A public benefit organizations. So donations to them will allow you to get your income tax donation, and that limit is actually the normal limit of 10% of taxable income has been increased to 20%. So yes, a very beneficial tax relief measure that dominant firms could possibly leverage off at the moment, and get your income tax deduction in respect of donations. Maybe again, not specifically helping you with more focused on the empowerment side in terms of your socioeconomic development expenditure, but yes, from a tax perspective, certainly beneficial. I think just to end off, it is evident that the tax provisions are not necessarily, again, completely aligned with some of the other pieces of legislation, including the BE legislation and the Competition Amendment Act legislation. But that's to a large extent to be expected. I think a lot of people comment on the fact that to use the fiscus as a way of developing SMMEs should be done very cautiously, and that initiatives rather through the DTI and other departments is more the way to go. And I think the critical issue from that perspective is that you don't want to narrow or erode the existing tax base. And so there's a very fine balance to be struck between providing incentives and mechanisms that enable growth for SMMEs, and that will ultimately actually enhance or widen the amount of sustainable SMMEs and the tax base ultimately. So I think that ends my portion of the talk. I hope I've given you some insight into some of the key tax issues and considerations that dominant firms should just be aware about. It is quite technical, but there's definitely certain ways and means you can do things that will be beneficial. So I think I'm just going to hand over now to Andries. I'm not sure if we possibly are going to answer some questions, but he'll take it from here. Thank you.
Thanks, Jerome. Thanks, Verushka. You're welcome to send questions through. We've got one or two coming up. One of the first questions that came through was a question regarding the price discrimination guidelines and whether the guidelines affect the granting of discounts to SMMEs or HTPs. We didn't go into the detail of how the price discrimination provisions work, but essentially the amendments are geared at protecting HTP or SMME firms against price discrimination initiatives that would somehow affect their ability to participate in the economy. And one of the most pertinent issues that arise in this context is the fact that under the previous version of the price discrimination provisions, one of the grounds that you could use to justify price discrimination was on the basis of cost savings that you might have enjoyed as a dominant firm because you supplied greater volumes. So the volume discounts that you passed on to your clients because they bought greater volumes of goods could be justified under the previous version of the Section 9. Currently, that basis or that justification ground has been removed when you're dealing with SMMEs and HTPs. So if you are granting significant discounts to firms that buy large volumes, for instance, and you're not giving those discounts through to smaller firms, the granting of the discount under Section 9 is seen as a form of price discrimination because the price that the customer pays is essentially the price after taking into account the discount. So to the extent that smaller firms don't enjoy the benefits of these discounts, well, there might be a risk that that the pricing is seen to be discriminatory and potentially then affects these firms' ability to participate in the economy. If discounts are being given to these firms, perhaps to a select class of HTP firms or SMME firms that fall within these categories that we've talked about. If these discounts are being given to them in order to equalize their prices with those of larger customers, well, that might be a way to selectively adjust pricing in order to be compliant with the provisions of the Competition Act, and I think that would be permissible. It might also be that certain of these discounts could be taken into account for the purposes of contributions under the BE legislation. I'm not sure, Verushka, if you might want to comment on that aspect, namely, you know, if you do give specific discounts to firms under the price discrimination provisions, would they then be eligible for to be taken into account under the payments made to firms that qualify for protection under the BE legislation?
Andres, discounting is certainly a mechanism that's taken into account as a form of enterprise development contribution. So it can be applied. One would just have to consider that proposal in a bit more detail.
Thanks. So we have had a few further questions regarding the slides. People who've asked to receive the slides, we will be circulating them afterwards, and we'll also be circulating perhaps the recording once we've just edited it. And if there are any other questions that anyone has, please send them through. We'll give another minute or two before we close out. Finally, if there are no further questions, I'll just hand over to Verushka, perhaps to address some closing remarks regarding the question whether there should be greater alignment possibly between these provisions in the Competition Act and the BE legislation. Is that something that you believe should be considered, Verushka?
Andres, I think the provisions are different in their approaches. So on the one hand, the BE legislation seeks to create incentives for becoming more BE compliant, whereas the Competition Act provisions are prohibitions on particular behaviors. So at least on the one hand, there's a positive approach that one can take, and maybe there should be some level of alignment to encourage the positivity of it. On the other hand, I think what would be helpful is if the legislation was made to align in respect of the use of classifications and definitions, and that could be beneficial. Thanks, Andres.
Great, thanks, Verushka. We're nearing the end of our session. I think we had an hour allocated, and we're basically at the end of our session. So thanks very much for participating. I hope you found the session useful. We're more than welcome to address any queries to us afterwards, and we will then proceed to give you an update or copy you on either a recording or summary of this this presentation. Thanks very much.